Hi everyone, and welcome back to our video series on recent data protection decisions from the Court of Justice of the European Union. Today I'm joined by my colleague Rosemarie Blake from the Technology and Innovation Group here at Arthur Cox, and we're going to be discussing a case that considers what constitutes personal data.
Thanks, Aoife.
So, approximately 6 years since the implementation of the GDPR, questions still remain over what can constitute personal data. Can you tell us a little bit about the case that we'll be talking about today?
Yeah, so the case is C31922, Gesamtverband Autoteile-Handel EV versus Scania CV AB. And the case concerns several queries from a regional German court arising out of a dispute between Scania, a manufacturer of heavy goods vehicles, and an independent operator. The independent operator contended that Scania should allow independent operators access to certain information and shouldn't limit this access to repairers. From our perspective, what's of interest from a data protection perspective is that the CJEU had to consider whether vehicle identification numbers constitute personal data.
Thanks, Rose. And to remind our viewers, vehicle identification numbers are different to vehicle registration numbers. Vehicle identification numbers are alphanumeric codes used by the automotive industry to identify individual vehicles. Can you tell us what the court took into account when considering whether vehicle identification numbers are personal data?
Yeah, so repeating the position from the Breyer case, the CJEU held that in order to determine whether a natural person is identifiable directly or indirectly, account should be taken of all the means reasonably likely to be used either by the controller or any other person to identify that person, without, however, requiring that all the information enabling the person to be identified is in the hands of a single entity.
And what did the court say then in relation to applying this to vehicle identification numbers specifically?
So the court took the view that the vehicle identification number as an alphanumeric code assigned to the vehicle by its manufacturer in order to ensure that the vehicle is properly identified is not personal, but it becomes personal in respect of someone who reasonably has means of enabling that alphanumeric code to be associated with this specific person. Ultimately, the court held that the vehicle identification number constitutes personal data of the natural person referred to in that certificate, insofar as the person who has access to the certificate may have means enabling them to use it to identify the vehicle's owner or the person who uses the vehicle.
Okay, interesting. And did the court provide any guidance on the means reasonably likely to be used to identify the data subject?
Unfortunately, the court left this key question open. Recital 26 of the GDPR provides more information than judgment itself, i.e. account should be taken of all objective factors such as the costs, the amount of time required for identification, taking into consideration the available technology at the time of the processing and technological developments. So the assessment criteria for reasonably are still unclear. For example, it's not clear whether that means theoretically possible or practically possible.
Okay, I don't think this is the last we'll hear on the topic.
Definitely.
Thanks very much for your time today, Rose, and thank you all for watching.